classification where the law is made only for Assam. I'll just, my lord, paraphrase my submission, not going into it. There are several provisions under the Constitution of India which applies only to particular states, including the state of Assam. So there can be a law applicable only to one state. My lord, page 49, I have, my lord, pointed out the provisions which are applicable only to Assam. My lord, these are my respectful submissions. Only one thing, my lord, as a last thing, as I, my lord, I have some kind of an apprehension. But I would request the interveners to keep in mind that they are here to protect 6A, meaning thereby they represent people from 51 to 71 and not post 71. So, my lord, their submission may not be such that though we are on the same side, I have to give rejoinder to them. That's all. My lord,
the validity of 6A.
Only validity of 6A. Article 6, that is 11 present, my lord, slight modification that further becomes, my lord, nothing contained. Article 6 makes it absolutely clear that notwithstanding the provisions of these articles, Parliament will have power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Any defects that experience may disclose can therefore be easily rectified. The Parliament get experience, they need more qualifications, they need to take away citizenships, not concerned in this case, but generally by only one state, why not Tripura, etc. Now, my lord, your lordships have, my lord, on the last day when my learned friend was distinguishing the judgment which I was to cite, have seen, my lord, at page 21, on interpretation of Article 11, that is, my lord, Izar Ahmed Khan versus Union of India. My lord, this is the judgment by 5 honorable judges, my lord. I'll read the highlighted part. It's, my lord, authored by my Lord Justice Jitendra Kumar. My lord, at page 21, bottom highlighted part. Article 11 confers and recognizes the power of Parliament to make any provision with respect to not only acquisition but also termination of citizenship as well as all matters relating to citizenship. Thus, it would be open to the Parliament to affect the rights of citizenship, and provisions made by the parliamentary statute in that behalf cannot be impeached on the ground that they are inconsistent with provisions contained in Article 5 to 10 of Part 11, Part 2. So clear that 11 is an independent power and it can add to.
Just read the next sentence also. In this connection.
Yes, I'll just, my apologies. In this connection, 246, it is important to bear in mind that Article 11 has been included in Part 2 in order to make it clear that the sovereign right of Parliament to deal with citizenship and all questions connected with it is not impaired by the rest of the provisions of the state part. Therefore, the sovereign legislative competence of the Parliament to deal with the topic of citizenship, which is part of entry 17 list 1 of the 7th schedule, is very wide and not fettered by the provisions of Article 5 to 10 of Part 2 of the Constitution. This aspect of the matter may have relevance in dealing with the contention raised by the petitioners that their right under Article 19 are affected by the impugned provisions, etc. So, my lord, this is the only judgment, my lord, on Article 11, but even textually and keeping in mind the drafting history, the only inevitable conclusion is that they say we cannot conceive of many future situations, we leave it to Parliament. So, my lord, this distinction between deeming or conferring, my lord, may pale into insignificance. My lord, page 24, your lordships may not read, I have just given, my lord, the words which are used in the Article 11, which starts with nothing in the foregoing provisions, my lord, are used only in these articles. So it is, my lord, elevated to that level. That's all, my lord. Nothing beyond, my lord, turns upon that. My lord, Article 324, my lord, my learned friends have not also, my lord, seriously pressed, my lord, so I'll not trouble your lordships with that. Please directly come to page 29, my lords. My lord, Sarvanand Sonowal judgment, I have just said, my lord. Sarvanand Sonowal judgment was concerned with one act.
MDTR.
And the argument was that look at the serious situation on ground. This act does not fulfill the object it seeks to achieve. And on that ground, Sarvanand Sonowal was declared, was pronounced, and that act was declared unconstitutional. It in fact supports that this is a huge problem. But your lordships are not, my lord, right now concerned with right, my lord, correctness or otherwise of this judgment. Then, my lord, scope of judicial review in relation to treatment of foreigners, my lord, I may not trouble your lordships with. My lord, please treat this as read, my lord, because your lordships are aware of the settled propositions of law on this. My lord, challenge concerning Article 14. Where I'll read, my lord, only one or two judgments, my lord. At page 35, this is a judgment by 7 honorable judges, special court bill. There are numerous cases which deal with different facets of problems arising under Article 14 and which set out principles applicable to questions which commonly arise under that article. Among those may be mentioned the decisions of so-and-so, so-and-so. Then, my lord, highlighted part. But as observed by Justice Matthew, in the last mentioned case, it would be an idle parade of familiar learning to review the multitudinous cases in which the constitutional assurance of equality before the law has been applied. But, my lord, thereafter, my lord, at page 36, the Honorable Court, 7-judge bench, my lord, earmarks what are the contours your lordships would consider while, my lord, examining a challenge under Article 14, and relevant, my lord, all are relevant, of course, my lord, but please come to 5, just, my lord, at the foot. On the classification, my lord, my learned friend's argument was there is a classification. Well, I'm dealing with that submission, my lord. By the process of, your lordship gets that, my lord. By the process of classification, the state has the power of determining who should be regarded as a class for the purposes of legislation and in relation to a law enacted on a particular subject. This power, no doubt, in some degree is likely to produce some inequality, but if a law deals with the liberties of a number of well-defined classes, it is not open to the charge of denial of equal protection on the ground that it has no application to other persons. Classification thus means segregation in classes which have a systematic relation usually found in common properties and characteristics. It postulates a rational basis and does not mean herding together of certain persons and classes arbitrarily. The law can make and set apart the classes according to the needs and exigencies of the society and as suggested by experience. It can recognize even degree of evil, but the classification should never be arbitrary, artificial, or evasive. The classification must not be arbitrary, must be rational, etc., etc. My lord, your lordships are well aware of the propositions, my lord. So I will not, my lord, trouble your lordships with that. Please, my lord, come to the case of, my lord, Ajayab Singh, which is at page 38 at the foot, my lord, para 111. That, my lord, lays down substantially the same text. My lord, I may even, my lord, skip that. So please come to page 40. My lord, under classification, my lord, I am duty bound to answer on facts on the question of Bengal. But my legal proposition, my lord, is this. And I will do that, my lord, in the within a day or two by way of an affidavit filed by the Home Secretary. But the argument is, instead of 1, you should have done it for 5. So argument is of under classification. That may require law to be made for others, but would not be a ground to declare the law already made ultra virus. Lord, first judgment is N. Venugopala Ravi Verma Raja versus Union of India. And please at page 41 see, my lord, the highlighted part. So under classification is always not a, my lord, ground of a successful challenge on Article 14. But the mere fact that the law could have been extended to another class of persons who have certain characteristics similar to a section of Hindus but have not been so included is not a ground for striking down the law. In treating a Hindu undivided family as a unit of taxation under the Expenditure Tax Act and not a non-Hindu undivided family, the Parliament has not attempted an obvious inequality. Then, my lord, Ajay Kumar Banerjee, only highlighted part, we may reiterate that Article 14 does not prevent legislature from introducing a reform, that is, by applying the legislation to some institutions or objects or areas only in according to exigency of the situation, and further classification of selection can be sustained on historical reasons or reasons of administrative exigency or piecemeal method of introducing reforms. Maybe for other states law may come, but that would not make 6A ultra virus. So special provision for one state historically because of Assam Accord, etc. Ambika Mills, my lord, is a settlement. I'll not read that, my lord. Then territorial classification, your lordships would get, my lord, 43, page 43. Territorial classification is justifiable. Lord, this is my submission in law. Lord, factually, since it has fallen from the court, my lord, and the court, which is a constitutional court, taking care of fundamental rights of everyone present here or otherwise. Lord, I must answer the question regarding, my lord, territorial classification, why not Bengal,